Holy moly.
Okay, we're recording.
Great. Let's see if there's another person waiting to get in. Then we'll start. Okay. Okay. Good evening, Hammond North. It's March the 4th, 2026, and this is a special meeting of the board. Call to attendance from the screens I have. Randy Vaughn,
Excuse me, here.
Joe Patton,
Here.
Chris Conti,
Here.
Jan Welch,
Here.
Tim Fritz,
Here.
Tracy Smiler.
Here.
Okay, before we get to the business, I just want to reiterate that we were able to sign a contract on Monday. So the contract is in effect, which means we'll discuss it later, the various deadlines we have and what it's going to take to actually go all the way to closing. So with that, Randy, some minutes.
Yeah, I move that we approve the special meeting minutes of February 25th. Those were sent out a couple of days ago to the board for review.
Is there a second?
I'll second.
Jan seconds. Any discussion from board members? Okay, call a question then. All those in favor, raise your hand. Okay, so it's unanimous. Okay, thank you. Then I would like to just make a few other announcements about board meetings. One is that, as I've said to some owners who have raised questions, that we really would like people to raise questions only on the topic that we're discussing. And if we're through with our agenda, they have other topics we can get to, but we should really keep to the agenda. Along with that, we'd like to limit owners' questions or statements to 2 minutes with a follow-up question. And beyond that, if it comes around again, people are welcome to ask another question, but we'd like to limit that to 2 questions or statements per agenda item. So that's, and again, as I said before, on the topic that we're discussing. So with that, then approval of that we did the minutes. I think that's it. The next thing would be payment of invoices.
Yes, I'd like to make a motion to approve the fitting law firm invoices for services rendered in December. We went through the motion, but there was one component of that unanimous motion that did not pass. So I'd like to bring these back forward. So I move to pay invoice 47060 in the amount of $88 for fees associated with the Burnham case.
Is there a second?
Second.
Okay,
Oh.
that's Randy. Okay, any discussion? Okay, all those in favor, raise your hand. Okay, unanimous. Okay, next one, Tracy.
I'd like to make a motion to again pay the Finney Law Firm invoices for the month of December in the amount of $12,891.62 for partition action from December.
Okay, is there a second?
Second.
Okay, I take that's Tim. Any discussion? All those then call the question. All those in favor, raise your hand. Okay, thank you. That's unanimous. Next one, Tracy.
I'd like to make a motion to pay Finney Law Firm invoices, invoice number 47061, again for services rendered in December for the Cross Creek case in the amount of $352.
Is there a second? That's Chris Conti. Any discussion? Okay, all those in favor. And again, Randy, you're voting on this one?
Oh, I'm sorry, yeah.
All
Letting
in favor?
people in still here. Okay.
Okay. Next one, Tracy.
Again, like to make a motion to pay penny law firm invoices for services rendered back in January. Invoice number 47064 in amount of $5,836.44 for general corporate services.
Second.
Is there a second?
Second.
All right, it's Tim. Any discussion? Yeah, Gil.
You see, I think you just said January. Isn't this a December invoice?
This is a December with the date of January when they sent it to us.
Any other questions? Okay, all those in favor? Okay, that passes unanimous again. Any more?
Yes, the last one for Fanning. Again, like to make a motion to pay the Fanning Law Firm invoice for services rendered in December. Invoice number 47065 in the amount of $1,208.50 for the Porter case.
Second on this one?
I'll second.
Gil, that's why his hand first. Okay, any discussion? Okay, call the question. All those in favor? Okay, Jan, you voting on this one? Okay, unanimous, okay. Are there other bills, Tracy?
Yes. So first, before I get to the next bill, I just want to say that the owners can see these invoices on the January Treasurer's Report as what I just read off. I'd like to make a motion to pay the Allen, Stovall, and Newman attorney fee, invoice number 50288. This is for some bankruptcy services that was provided back in October. This invoice kind of fell through the cracks for the services back then. The amount of this invoice is $2,015.16.
Is there a second? Okay, Jan, I'll take Jan on that one.
Good.
All right.
Okay.
Any discussion on this one? Then I'd just like to add that it did fall through the cracks. It didn't fall through the cracks at our end. These fell through the cracks of the attorney who's doing the bankruptcy proceedings.
Yep.
Any other comments? Okay, all those in favor, raise their hand. Okay, it's unanimous. Any others?
Yes, I like to make a motion to unanimously pay another Alice Silver attorney's fee invoice 50433 for services back in December in the amount of $2,386.96.
Is there a second? Okay, it's a Randy on that one. Any discussion for the board?
This is another bankruptcy invoice.
Yes.
It actually is an invoice. There are three of them, and they're all invoices for work they did on the same bankruptcy case.
Bankruptcy, yeah.
They billed us on the other ones. They didn't bill us on this one.
And you should have it in your email as well.
Yep. So, any other questions? Okay, all those in favor of paying this invoice? Okay. And there's one more, I
Yes.
think.
I make a motion to pay the last Allen Stovall attorney's invoice, invoice number 50590 for the same bankruptcy services that were performed in January in the amount of $2,430.96.
Okay, is there a second?
Second.
That's Tim. Any questions about this one? Okay, all those in favor? Okay, that passes. And is that the last one, Tracy?
That is it. Thank you.
Okay. All right. Then announcements, external water leak update from Greg.
Yes, John, thank you. Good evening, everyone. As of 5 o'clock this evening or this afternoon, the repairs to the exterior pipe leak is essentially completed. They'll be back again tomorrow to pressure test the repairs and refill the hole. And at some point going into next week, weather permitting, Tim and I will patch out the surface to totally complete it. But as of tomorrow, probably midday, everything will be. We anticipate everything to be back up and running, and that includes that, John. Unless there's any questions.
Tim,
Was the scope as anticipated, Greg?
Yes. Fortunately, it was. We did run into some complications, but it did not increase the scope or the cost. Fortunately.
any questions from the board, other questions of the board or owners? Okay, thank you, Greg.
My pleasure.
Let me just add, since this is a special meeting, there isn't the usual building manager report, but Greg and I had talked about question of owner bills, monthly bills, and some of them are delayed in the mail. And everybody should know, and it'll be reflected in the minutes, that owners can request an email of their bill. And so that's one thing that they can take care of. The other one is that sometimes the way the software works, what I've heard from Greg, is that it's not itemized what the costs are if it's a costs that are running over from previous bill. But every owner can get the ledger, and the ledger is a listing of the date, the amounts, the reason for the charge, and a running total. So any owners, if they have questions of any of their bills, they can ask Greg for that. I don't know if there are any questions by board members about that. Any questions from owners on that? Okay, that update, and then I think the legal update is next. Randy.
Okay. All right. Yeah, with the cross-crease suit, I know I told everyone last week that was essentially agreed to, and we were waiting for signature. There was a bit of a hitch. Part of the one of the documents that we asked the plaintiff, Cross-Crease, to sign, it was still being. This was to be signed for the benefit of our buyers, and there was a delay in the creation of that statement. It's now been created and approved by everybody. And that was, I sent that to Ian, what day is this? This morning, I believe it was. And he had to give that to Cross-Crease. He spoke with Cross-Crease. The sister, the daughter of senior Mr. Cross-Crease, has the POA in that suit or in that situation, and she is also the trustee involved as well. She is the one then that needs to sign that. She's out of town. She will be back tomorrow, sign it, and we have been told that we should have that by Friday. The final documents, and yeah, that would then be submitted to the court for their approval, and that should be the end of that case. In Burnham, there's really no update. Julie is I don't know if she has drafted or is drafting the settlement. We have, as I mentioned last week, we've agreed in principle, and we're waiting for that form to be completed and distributed to the other plaintiffs in the case, which are 3 insurance companies. And when that is signed, we'll submit that to the court, and that should be finished. I don't have a timeline, though, specifically for that. In the Porter suit, we will be discussing this in more detail, well, not in more detail, but further in the executive session. Yeah, and the buyers have asked for all plaintiffs in all the lawsuits against the association to sign a covenant not to sue the buyer in the future. And we are hoping then to at least get that much taken care of with the Porter plaintiffs. But yeah, that's about where that case stands at this moment. Did I
Before
miss
I-
anything there, John? Or I think that's kind of where
Well,
we
I'll
are.
add something, but first I want to say that there are 100 participants on the call right now. We realized this afternoon that we should expand that, and the way Zoom works, it's up to 500. So we put that in. We weren't sure it was going to work for today. If we see 101, it will, but we'll let you. If anybody in the chat says they can't get in because they called another owner, please let us know, and we'll announce it. And might mean some people may have to get off or others to be on, but the call is being recorded. So for this, I'm sure there are questions. Let me just say with Cross-Creek, I'd like to go one by one. The first one that Randy went through, that the delay wasn't really in creating the form, it was more like finalizing the form. We
Right.
had the finalized form with edits. The buyer had sort of talked about that up to 2 weeks ago, but we couldn't send it out as the official final form till the PSA was signed. So the PSA was signed Monday afternoon, I think around 4 o'clock. So then by Tuesday morning, we sent that to Isaac to talk to Jordan to make sure the buyer said the form is good. We got approval later yesterday. And so quite frankly, I don't think it was much of a delay. We couldn't have really done it that much earlier. So let me open up for board questions on Cross-Curry. How about owner questions on Cross-Curry? Please, only Cross-Curry. All right, move on to Burnham. Any question on the Burnham situation from the board or from the owners?
I have a question.
Sure, go ahead.
My question is, will the settlement take care of our loan that we have on the property?
Yes. Terms, I'm sorry, the Burnham case or the Cross-Curry?
This is the Pellmans.
He's asking a question off topic, John.
Okay,
He's
Well-
asking about his personal loan.
It's a
Yeah,
loan.
let's get to that when we
Took
talk
out
about the
a
sale of the
loan
building.
to buy the property. Is that going to be taken care of?
The owners, the buyers who are buying our building, they don't need a loan. They have sufficient funds to buy the building.
I'm not talking about that.
Yeah,
Okay.
yeah.
I'm talking about the fact that we took out a loan to buy our condo. Is that
Oh,
going to be taken care of in the settlement?
Right. Can we just hold that question till we get to the PSA and finish the legal cases? In
Okay.
a nutshell, in almost everybody it will, but let's hold that to the PSA. That really is a question. It's a good question for when we sell the building. What does that mean in terms of people mortgages and arrears? But in terms of the cases, if there are no other questions about Cross-Creek and Burnham, let's move on to Porter, which I would request that people who have stated their position in the past, I don't think those positions need to be restated, but are there any questions on the Porter case from the board first? Or from the owners? Michelle?
It's muted.
There you go.
Yeah, I do have a question about the Porter case. So my understanding from what's happening is we are trying to get all consents to sell, and everybody keeps saying we're going to be able to sell the building regardless of whether the Porter case is settled. Is that accurate?
I think it is.
Okay, so here's my question. In the letter that Diana Porter sent out to owners, the attachment attorney basically said if we don't settle for the 2 million from the DNO, they're going to sue us in excess of 10 million or more. So how do we settle a lawsuit if there is this enormous outstanding potential liability? And how does that impact owners? Thank you.
You know, first of all, it's hypothetical. and anybody can sue for any number of reasons. I mean, I think the board is unanimous in trying to settle the Porter case, either before we sell the building or after. We don't want to.
So John, I'm going to just interrupt for a moment because according to the information that was sent out to owners from Diana Porter and her attorney, the deadline is past what they gave the board to settle. Is there still settlement negotiations going on?
It's a good question. There have been emails back and forth. I think the board generally feels we're open to discussion. I've had an email to Ian as to what's going on, but I haven't had a response yet. I will follow that up tomorrow.
But it's reasonable for, as an owner, based upon the information provided directly by the person who's suing, to assume that negotiations are over and that they're going to proceed to go to court.
Let me do a brief answer, then if you, all due respect, let's see if other board members, Randy.
Yeah,
and
no,
other
thank you.
board-
That's all I have.
Wait, and Michelle, let me finish, which is that, I'm sorry, spaced out on that one. Let me, basically, there are a lot of allegations going back and forth. We're aware that some of them on Facebook. I'd rather not. My personal view is not to answer each one of those allegations. I could have private conversations with people, but on this recorded board call, my personal view is I'd rather not get into answering her allegations. They're allegations, they're assertions.
No, that's not my point, John. My point is that the information that was sent out to all owners by Diana Porter with the attachment from the attorney had a deadline that said if you didn't meet the deadline, it was last week, that would be that they would move forward with discovery and basically move forward. What I'm asking for, and then sue for greater amounts. So I am just trying to understand how this all plays out. So if that's not something you can provide at this point, then I respect that. And I appreciate everybody's hard work on this. Thank you.
Yeah, I would just say that we have had no communication with the plaintiffs, which all that communication would get through from Lundgren, from their attorney.
Right. And that's what I'm referencing with the letter Diana sent out and the attachment she provided from their attorney.
Okay. David?
I was just curious what the news is since the last meeting. What's changed?
Much.
Not much. Is that what you said, Randy?
Yeah.
Okay. All right. Short
We're
question.
working on it, but officially not, not really a whole lot has happened.
Okay.
Not with that case.
Uh-huh.
Paulette? Can you unmute Paulette?
Yeah. Okay, there you go. Paulette, can you unmute that?
Thanks, I've been trying to. Yeah, I sent a letter to the board and hadn't gotten any response about that case, because from my reading of that letter that Diana sent out from their lawyer, it sounded, it took me a while to understand because there's so much legalese in that communication, but once I understood it, I really felt like there was a legitimate demand in the mediation, and they had relinquished so much. But this one thing that could get $2 million that the first lawyer for the first board, that your board currently is engaged with the same thing, that he was misinformed, that he made a mistake. And it sounded like this current lawyer's not admitting the mistake. And so I never got a response to that, and maybe you can't say anything about it, but I just really felt like that was a really legitimate concern that was raised in that letter. So.
Could you be specific what the mistake was, or do you rather not?
The mistake was the letter that said they had a right to review, and then that letter was being said as a refusal of the insurance company to pay. And it wasn't a refusal. It said they have a right to review. And so that's where as I understand it, that's where the mistake was, or the false thing that's been being said over and over again. Well, they said they wouldn't pay, but that's not true. And
Randy?
I wondered why the board isn't recognizing that.
I think we recognize the point, but Randy, do you want to comment more about that? I think you're referring to the CNA letter, and CNA's coverage.
CNA, I don't remember what that means.
CNA is the insurance for the directors and officers. So
Right,
that's
right.
where the 2 million policy.
Yeah.
So it's a question of the letter that they wrote to the board on June 4th, 2024, I believe, and their policy and their coverage.
I guess I don't know those details, but I think it was where they said they had a right to review. And that was interpreted as we're not going to pay at all, instead of we have a right to review, which is standard apparently. So it's just that there's a lot of money at stake there and we paid a lot of our fees for other lawyers instead of the DNO lawyers. And so just thinking we don't want to pitch that money away for no good reason.
Randy, did you want to contribute at all on that?
Let me frame it. Okay.
It's a difficult one. It
Yeah,
really is the one getting into
I don't know
it.
what, well, okay, let me see. Okay, first of all, our lawyer is reviewing the policy and will give us her opinion of what it says. I do know in the policy that it says that for liability issues, $2 million is the maximum. It's an aggregate number, which includes the cost of attorneys that the insurance company needs to provide for the board. So that's what I know. I am not a lawyer who can read these silly policies and know what they mean, but that much I did quite understand. But that's I think all I can really say at this time is that we are looking at the policy to see what it says. As I mentioned in my report, we are going to discuss this further in executive council as to what our next move might be. And yeah, I think that's where we are.
Jan?
So I want to be clear, Paulette, what you're asking or what you're saying.
I'm sorry. Jan, you should be, can you unmute Jan? I accidentally.
There she did.
There we
Okay, it's
go.
good.
Paulette, are you saying that you think the $2 million is just there and we just need to ask for it?
No, I think that I don't know what's involved with changing this lawyer. You engaged the same lawyer, right? That originally said that they're not going to pay. They're not
Oh,
going to
the lawyer didn't write that letter. It was the insurance company adjuster who wrote that letter.
Right, and the other one the other one, Paulette, is the attorney that we're talking about, the CNA's attorney, who represents the board, perhaps also CNA also, paid by CNA, we don't have control of that. CNA says they will provide legal coverage to the board, and they hire their attorney. So it is the same attorney that the previous board hired, who's been involved in the case. It's a Reminger law firm, and they have been involved from the beginning.
Well, when I called Diana to say, what the hell does this mean? I don't understand it. And I listened and she explained it well. I felt like it was a situation where a lawyer inadvertently or purposefully did not read it right and is still holding on to that position and when it needs to be changed.
I think the letter is posted. If not, we should post it. But the CNA letter says two main things, regardless of what you think of the letter. The letter says, one, because of the lawsuit, the Porter lawsuit, we will pay legal fees to defend the board. Two, it says their opinion, this is CNA's opinion, the insurance company, that they're not liable to pay damages in this particular lawsuit. It's much longer than that, but that's what they're saying. Anyway, can
Okay,
Tim
we can
and
let- we
Tracy,
can Let it drop for this
Here's-
purpose
here's
of
the-
this
here's-
meeting, but I just think that the lawyer that's for the plaintiffs has spelled it out really pretty clearly, and I just thought it made sense.
Paula, here's the thing that you have to understand. There are three attorneys involved here. There is the attorney that represents CNA. There is an attorney group that is representing the board that was hired by CNA. And then our board attorneys are also involved. The CNA attorney is the one who wrote the letter that said they are not responsible for the damages. The attorney that's representing us, that's representing the board and the plaintiffs, has nothing to do with that whatsoever. And our attorney for the board is reviewing whether the CNA's letter is correct.
okay, I think we should move on, and I muted Paulette, but we can follow up individually. Sally,
I've been able to see the email from Diana Porter and the attached letter from her attorney to another attorney. And frankly, I find the letter rather threatening. And I'm confused as to why that was made public. Why did she send that out to people? It was a communication between two attorneys. Yet she sent it out. I don't understand what the motive behind that is.
Sally,
It's just a
And if
comment.
I can speak to that, that's why I look like such an idiot sitting here. I'm trying to preserve the confidentiality and not litigate this thing in public. And it's hard to do when someone on the other side has brought this out to the public in an attempt to get us to do exactly what we're doing now, which is to fight among ourselves and question whether we are right. Yeah, okay, I'm
I
done.
understand. I understand. It just raises in my mind another question about the plaintiffs and why they're doing this. And it's just my comment. I'm sorry.
quite frankly, Sally, quite frankly, that's one of the things that has complicated this issue.
It certainly has. And I think they need to be held accountable for it. But there isn't going to be a way to do that.
okay, thank you, Sally. Are there any other owner questions about the Porter case? Okay, then I think we should move on for the PSA. Let me just basically review what the timeline is. Well, one, the contract is posted on the website so people can read it. Number two is what is the timeline on this? First of all, there's 15 days that started counting on the day it was signed, which is March 2nd. Those 15 days expires on March 17th. On March 17th, we have to have all 180 consent to sell forms. Everybody knows there are 4 left to go. And then we also need forms from the plaintiffs, and that includes the Crosby and the Porter plaintiffs, that basically says that they will, as Randy said, they will not sue the building. So that's 15 days. When those 15 days expires, then it's 45 days of due diligence, where the buyers will look at the building and figure out all the ins and outs, what they have to do. And in 45 days that expires. Sometime, I should say today or tomorrow, they have to put $100,000 in an escrow account. That escrow account is held in the prominent title company. And when the 45 days of due diligence expires, then that money basically cannot be pulled back. After the 45 days, then it's 30 days for us to have 180 quitclaim deeds. So if you add that all together, that we have basically 15, 45, and 30, we have 90 days in which to get 180 quitclaim deeds. We don't need those deeds before that. The committee is working on that, but we need them. Obviously, it's a lot of deeds, a lot of questions, and we have to work on that before that time expires. Tracy, you had your hand up, but then it came down. No, okay. All right. Randy and Tim, you've been involved in this negotiations. Do you have anything you want to add?
No.
No, well, no.
Okay, we do have.
I'm just thinking, Mr. Pellman's question about paying off the mortgages. I'm not sure if that fits right now or a little bit later.
Sure. I'll deal with it now. It's a reasonable question, which is that we've looked at the mortgages and we asked Finney to investigate the list of the mortgages, public documents, and then to figure out, given the date that the people got the mortgage to the current date, which was about 6, 8 months ago, what the mortgage would be with the normal rate of payoff. And that was an assumption. So that list was sent to me, and the board decided that we would not share it. I would not share it with anybody else on the board or the owners. That's really personal information, regardless of whether it could be public or not. We've looked at that, and we've done a spreadsheet that I created based upon, I inserted for the people who owed the most amount of arrears who are on that list, add those together, see what the total debt just from the mortgages and arrears was, and then figure out what the average high-level payout that Tracy's spreadsheet has been very helpful for this, and figure out for 1, 2, 3 bedroom or penthouse unit, what the average payout would be and whether that would cover the payout. From what we can tell, and we can separately later, Bill, find out exactly what those numbers are for you. We can do that later after the meeting, that there are only 4 units who might be underwater. And this is making a lot of assumptions that Tracy made, that she shared with everybody based upon what we think we're going to have. It includes the landmark money. It includes the reserves we have, what we expect the expenses will be, and we all have to update and what the costs are of selling the building. So as far as I know, Bill, I don't think you'll be underwater. But
Well,
Bill, do you have any follow-up questions, or Tim, did you want to?
The other thing I just want to say, John, is this is all a part of the title search process. We will zero in on these numbers in the next few weeks during the title search. Like you said, the numbers that we have right now are a couple months old, and we're using our best guess as to who might be underwater and who probably is not underwater. But that will all come up in the title search. That will be part of what the title company is doing, is resolving all these issues. And that's one of the things. I'm on the quitclaim deed committee, and that's one of the things that I put in my note to my people on floor 7 is that there's a couple pieces of paper that will have to be filled out by everybody. If you have a mortgage or if you have a lien, you might have more paperwork to fill out than just the typical two pieces of paper. Most people are going to have to fill out the deed and an escrow agreement. But if you have a mortgage, or if you have a lien or some other complicated paperwork associated with your property, you may have to sign more documents.
Let me also say that, again, well, Tracy, you go first.
Nothing. I was just gonna to add on to the question about the payout. Once we also get the HUD settlement statement for closing, I will be able to update the numbers around what those specific payouts will be. We would know what the closing costs are. We would know what any commissions would be. And so when we talk about, what owners would particularly get with the reserves and the sale of the building and costs, we would have a much better idea after we do the title search and get that HUD closing document. So.
And I was going to add, not just for Bill, for all the owners, if you look at Tracy's spreadsheet, which is posted on the website, and you'll figure it, you can, a number of bedroom units you have, you will then be able to figure out what we believe the payout for this sale will be. You can then subtract from that your mortgage, which you should have a much more accurate number than we have. You can subtract from that how much you're in arrears. And for almost everybody, it should be a positive number. And that would be your expected payout. But again, it's average with a lot of assumptions. So with that, before I go to Marion, any other board questions in general about the contract? And I should say for the owners, we have a subsequent item on their agenda of consent to sell quitclaim deeds, and we're going to talk about that. But if people have questions about the contract, let us know. Anyway, Marion.
Yes, can you hear me?
Yes.
Okay, I want to clarify. Did you say that we have now 15 days for the 4 owners who have not consented to sell to hopefully change their mind and consent to sell? What happens if they do not in the 15 days?
I believe the contract will fall apart.
Okay.
Now, that's an assumption. If I believe we're going to get probably a few more before the 15 days is up. So it's possible, I have no idea, if we have 1 or 2 left, whether we go to the buyer and say, give us another couple of days. But they have the right under the contract to terminate the contract. Randy.
Yeah, we keep saying 15 days. Actually, this began on Monday when this thing was signed. I think March 17th, which is 2 weeks from yesterday, is the deadline to get all of these 180 forms to the buyers.
And it's really technically 3 more we need, right? Technically.
It's technically
3.
Well,
We need 3.
the missing consent forms.
Yes.
Well, I mean, there are consent forms that have stuff written on them. We think
Can I
that,
report on that?
That doesn't matter.
Oh, sorry.
Okay.
yeah, Jan will report
We
on
jumped the
that.
gun.
So, Marion, did we answer your question? And I'm sorry, you muted again. Yeah, we answered your question. Okay. So, anything else about the contract? Then we turn to Jan on the quitclaim deeds. Okay, Jan, go for it.
So there's one other thing that we normally talk about up front, and I wanted to mention that we've had another loss, another death in our community. Many of you know Don Ruxnagel, who passed away on February 14th, I think it was. Somehow that happened and word didn't get out to a lot of us until a couple of weeks later. So I wanted to mention that tonight, that Dr. Ruxnagel had passed away. So on to my report about consent to sell and quitclaim deeds. As has already been reported tonight, we have 176 consent to sell forms. We're looking, there's a possibility, there are 2 that we practically have. And so we hope to be able to give another report on that within a couple of days. I don't really want to say any more than that about it until we have it, because it's just, until we have them in our hands, I don't like to count them. On to quitclaim deeds. That report is longer. As you know, we have a new company that we'll be working with, a new title company, and it's called Prominent Title. It's been Isaac likes it. Isaac likes the people, knows the people, and has already been interfacing with them for us in very positive ways. This was chosen, I think most of you know that it was chosen by the buyer, and that it was a turn for us because we had already been talking to Ivy, and the floor reps have been talking to you about how Ivy was going to do this. So the good news is that Prominent is very flexible, and I think is very qualified to get this done. In some ways, it may require a little less work on our parts because they're willing to take responsibility for contacting everybody. But there's really a lot to figure out. So people are asking questions that we would be able to answer had we not switched companies that we're not going to be able to answer yet for a while. But we don't have time. I mean, it's all in a dreadful hurry. But on the other hand, we have time to get these questions answered. Now, for example, Chris Conti, Chris, you're on the call, right? I know you have
Yes.
going on today. Chris and I are liaison with Prominent, and Chris is getting a lot of our questions answered. They're very forthcoming with information. The types of signing and contacts will remain the same. And those were, well, I'm reciting them off the top of my head, not in the order of the sheet that they were on. But US mail, email, electronic signing, and there was one more. I forget what that was, but you've heard them before. And
In person.
Thank you. Yes. But there are some different nuances with that. And electronic signing is probably the more, we really need to come down on that. That one's going to be different, I think. They already have the title searches from Finney that were done in 2025. So we're ahead of the game there. And they will work with Ivy, and Ivy works with them. The guy at Ivy and the guy at Prominent have already been emailing, so that's a very smooth relationship. Floor reps have been contacting people. If you have not been contacted and are concerned about it, contact Janet Schoenbachler. And I don't have her email address handy, but if you contact me, I'll get it for you. We cannot yet provide the address for drop off or email or mail. But that will come soon. And we probably won't, we may do a few test cases just to be sure it's working right. But other than that, we won't probably be doing anything for at least a week. I mean, we're doing stuff, we're laying the groundwork, we're getting the system straight, but you probably won't be getting any deeds for at least that long. Let's see, by March 17th, we must have all the consent to cells, as you know, and the pace will pick up at that time. And John's already, and maybe others have gone through the timeline of 45.
Can't hear you.
We've already gone through the timeline of after the 15 days, which is March 17th, then 45 days for due diligence and another 45, is that what it is? Yeah, just total for until closing. So questions? And we're meeting with the floor reps again tomorrow on the quit claim deed. We'll be talking tonight further a bit about some of these decisions we have to make that are a little bit different. And I don't want to go in a lot of detail
Speak
about
up.
those things because I don't want to confuse people. But Laura?
Yes, this is Jana. I'm sorry. I'm talking under Laura's name. The reason that I'm speaking to you now is I have concerns. I hear you talking about the quit claim deed and how this is supposed to come about. And I totally have no problem with that. That sounds great. However, those of us that are listed as defendants on the partition complaint, I'm saying if everything works out fine and perfect and it sells then this is moot. It has no bearing. But those of us that are defendants on the partition complaint are still facing the fact that that the Hammond North and the plaintiffs have asked us as defendants to repay all of the attorney fees and all of the fees. Now, I understand we've already talked about this and the fees are being paid up front, but they have requested them back on the papers that are filed in the court with the petition complaint. Now, my understanding is that Finney has now petitioned the judge or the court and asked that the Hammond North and plaintiffs can file an amended partition complaint. First, I would like to know, why are we filing an amended at this point in time, and what is that about? And then the second is, why couldn't they move us from from defendants to plaintiffs, or remove the language that has to do with those fees when they do that amendment, rather than us all be hung in this? Because we're all going to be trying to sign a quitclaim deed when we're being sued. And if someone doesn't sign, those of us that are defendants are still hanging out there, and we can't get off of the defendant list, even though we agree 100% with the plaintiffs, except for being assessed the fees in the end. Does that make sense? I'm having a
Yes.
lot of trouble with this.
It's a reasonable question.
Yeah.
Randy, do you have your hand up, I thought?
Well, yeah. But no, I forgot what I was going to say. We will take that with first of all, the reason that it's being amended is some of the defendants, who are mortgage companies, asked to amend. And while they're amending, we're amending. But and that's why that happened. But that's a very good point. I will bring that to Julie's attention, that if we're amending this, can we drop the clause or the part of it that asks for defendants to pay, the legal costs and that kind of thing. That's a good point. As a matter of fact, I'm writing it down here so I don't forget.
Okay.
Ted?
Okay, can we unmute Ted? I'll unmute Ted.
Then I have something else too, John. Yeah.
So when do you need the quick deed? What date?
I don't know the exact date hand. I believe it's early June.
Okay, thank you.
Okay.
So-
And there should be, you want to answer that, Jan?
No, that was fine.
Okay.
We would like them by early June, because that's pretty close to closing.
Right.
Right.
After
That's
this
the-
15-day period,
As
when
soon as
we
possible.
get the consent to sell forms and we move on from that, yeah, then anytime after that, the title company will be producing these quit claim deeds for each unit. And as soon as you get it,
Right.
if you can sign it and get it notarized, or instructions specific to that will follow. But yeah, the sooner you can do it, the better, which
All right.
I hope will be, sometime in April or early May.
Okay.
Our plan is that as the deeds come out, you
Yeah.
will receive them, and hopefully we'll deal with them within a week after you get them or so.
Okay, what about those? What about those of us that are out of state? If we get it notarized here, would that be accepted in Ohio?
No, but there will be special instructions for you. They have notaries all over the country, and we're getting other instructions for people who are out of the country.
Okay, thank you.
Yeah.
And Jen, would you like to describe the system the committee has of floor captains,
Well,
floor reps?
yeah, I kind of thought we'd gone through that
Sure
before.
did.
But maybe I haven't. There's a floor captain, Janet Schoenbachler is coordinating those. There's a floor captain for every floor, sometimes two. And they are the contact people that are contacting everybody to make sure we have good contact information. That was difficult often in the consent to sell process, just reaching everyone. So we want to be sure we have good contact information, that we know your first preference as to how you would like to do this, email, electronically, or in person, or by mail. And that we have the right information for you, so that it can proceed very quickly. And then the floor representatives meet regularly. We talk, anybody that we're having trouble reaching, does anybody else know this person? That kind of thing. And it's a wonderful group with a lot of knowledge. So one other thing I wanted to mention that I understand has come up is the type of title or the type of deed. In the contract, it references the type of deed several times, I understand, and it usually says quitclaim deed, but in one place it says limited warranty, I think, deed. And Isaac and the Prominent Title had a conversation today, and they agreed that that can all be done by, or mostly, unless there are some issues, can be done by quitclaim deed. So, Tim, did you have something? And then we'll go to Sally.
Yeah, I just want to clarify again on the timing of how this is going to work. What Ivy Title told us, and I'm assuming it's just going to be the same with Prominent, is that these quitclaim deeds will come over in batches. They won't all come at once.
Correct.
So we will distribute them as they come to us so that people have the maximum amount of time to do something with it. If you have a reason that you need your quitclaim deed soon, let your floor captain or Janet Schombacher know that so that we can prioritize your deed. As an example, if you're going to be out of the country and it's going to become difficult to do this, let them know and we can prioritize your request and move it up into some of the first batches that they're going to be putting out.
And my understanding is that, thank you, Tim, is that that the title company will be making contacts to you and getting the deed to you to sign, and that we will not be doing that. So that's a bit of a change, I think, from our understanding previously.
Randy?
Oh,
Yeah, I don't know if I want to, well, let me just, there's a question on chat asking, who are the floor captains? This person that put the chat in says that they have not yet been contacted. They would like to reach out to the floor captain. Do you have a list of that we can maybe put online or something like that?
we do have a list, and I'll ask Janet to do that.
And Jan, do you think it's okay? We can post it on the website?
I think so.
Yeah.
I think so.
Great.
All the floor captains have agreed that their information will be published so that owners can find out.
Okay, as soon as I get that, I'll post that, everybody, under important announcements on the website. But
Okay.
I'm sorry for interrupting there, Mary and Sally. Okay.
And Sally, I know you've been waiting.
I just have a question. Assuming that we get all of the consents to sell by March 17th, and the due diligence period begins then, and it's 45 days, what options does the buyer have during that due diligence period? Do they have an option of pulling out of the sale?
As far as I know, basically, I don't think they're held to any particular reason to pull out. I think what they do is there is Exhibit C that's in the contract, about 31 items that has to be delivered, I believe, by Monday. I've talked to Greg about that. He's assembling them. He doesn't think it'll be a problem getting it to them. So that's part of it. They have previously inspected the building, but in terms of reasonably looking whether they want to get into this, and they have a lot of information and questions, so I've answered them already. We expect there'll be more questions. And in the contract, it does say they have a right doing the due diligence to look at the building some more. So I hope that answers your question.
They don't have the option of changing their offer.
I don't believe so.
Mm-mm.
I think it's a signed contract. So I don't believe anything in the contract says you can renegotiate the price.
Okay.
Mary.
I was just looking at the calendar, and when I count up 90 days, it's before the end of May. Okay. So not June. It's the end of May.
You add the 15 days into that.
Okay, but there's 15, 45, that's 60 days. You add 30 more days, you got 90 days. Okay, it's the end of May. It's exactly before the last day of May.
Good.
We'll check that. You may be right.
Okay. I think that's important in terms of everybody's knowledge. I had a question for Jan. As I've been in touch with people, I thought I remembered that not only could you do electronic signing, like somebody will send it to you and it's you do a signature and send it back, but isn't there also the option to have a video call with people at the title company and handle it through that process? I thought we talked about that.
We did talk about that, and that's the problem with these floor reps. They're so sharp and they remember everything you say. So, at any rate, this company is going to be recommending a slightly different way of handling the electronic e-notaries, and that's really under that category. And I think there are a lot of options, and different title companies have different opinions about how they feel about those. Yeah, how, so we're working on it as fast as we can. I'm clarifying.
Mary, let me say that we did get, after we signed it, I think yesterday, we got a calendar list of the steps from the buyer, and it is broken down to each of the different categories. They have May 31st as a closing day. May 31st is a Sunday, so that would mean it'd be June 1st.
Okay, so, but maybe I hope you can clarify by tomorrow night. If we put electronic down, that could be a different way than actually a video call. I mean, could we use the category of video call as another category?
I'll put that on the list. I had not made that kind of a distinction, but it's probably very valid.
Okay, thank
But
you.
I don't know that we'll have the answer tomorrow.
Okay.
I cannot promise you that at all.
Okay, thank you.
Sorry.
Any other questions about the quitclaim deeds or the consent to sell forms? Can we unmute Paulette?
Yeah, I did put this question in the chat, but it's for Jan if we want to, because I just now today got freed up to start making contacts. And I wonder if I should hold off till after our meeting tomorrow, or until we find out if they're going to contact everybody directly themselves. Should I just hold off or go ahead and lay out?
You can ask it and we can see.
Say it again.
Go ahead and ask it, and if I can't,
Okay.
we'll see.
Okay.
You can
Any other
ask the question.
Any other questions about the quitclaim deed or the consent to sell form? Randy?
Yeah, this just, I know they are using a second company to do electronic signing. And there was an issue with billing on that. Are we still going to try to negotiate with that?
It's in process. Please wait. Please.
Well, thank you. You answered my question.
Sorry.
It's in the works.
Yeah.
Fingers crossed.
Yeah.
So that is the agenda that we had before we adjourned to executive session. Any other questions, any other topics or chat, Randy?
Yeah, there's a chat about the reduction of property taxes, the complaint against the thing. I saw that was answered on chat. Yeah, so I guess, okay, never mind. I guess that's covered.
Yeah, I would just say, without giving legal advice, that it is helpful to have some documentation to submit. The board can't really, there's individual owners, they have to do it. But there are documents if people go to our website, look at important announcements. There are a lot of documents that are posted there that may be helpful to your case. Tracy, do you have your hand up or?
No, I was just gonna implore that the owners on this call if you are aware of the individuals who have not signed and or yeah, I don't know if they're listening to this board meeting or not, but just please, 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 like, advocate on this. Again, the clock is ticking, and we've gotten very far, and I'd hate for this deal to fall apart. So I implore you guys, if you know who these individuals are, please sit down, talk to them, try to get us to the point where we can get this across the line. So I appreciate everyone's help. Jan and the consensus cell committee have done a fantastic job, and the rest of the board have done a fantastic job on the PSA. So just commending everybody and all this. This is from all the owners as well. But I'm trying to stay positive to get this over the line in the next few
And
days.
I think we're going to get it. I really do. It hasn't moved off 4, but it's going to.
Okay.
Thanks.
Okay, are there any other points, any other questions people want to raise? Okay.
John, get the chat.
Want to read the questions?
No, I said
Oh, copy the chat. Yes, I will. Do we have a motion to adjourn?
Make a motion.
Gail makes a motion, a second. Tracy seconds. All those in favor from the board?